Meeting to order, 3:02 p.m. Thank you everybody for joining us today. And just because Joan is supposed to come, I'd like to just take it out of order, our agenda. So we'll start with the chief counsel's report.
Oh yes,
Okay.
first of all, everybody knows Connie. She's the new chief counsel.
Mhm.
So this is
Hello.
her first
Connie.
commission meeting.
You don't want to do approval of minutes?
Well, I kind of wanted Joan to be
Want her to
here.
be present for that. I understand. Okay.
Yeah. And if she's not after Connie's presentation, then we'll approve it.
Okay, well, I can just get started, I guess. So, case status and litigation report on the Morning Hill Foods case. Still no decision yet from the ICA. I know it's been several years, 5 years. But update on the docketed cases with the commission. So we did have, and I think this was touched on the last in the last commission meeting, but 2 cases were docketed on August 17th, Lanting and Fleischer. So those cases are currently ongoing. We did have a scheduling conference last week on the cases, and the cases were consolidated because the respondent is the DOE in both cases. Consolidation is limited though, so it's consolidated for purposes of the hearing and discovery, but the both cases will have separate verdicts and judgments, just in case there's appeals and things like that. I have a conflict in this case, but I did talk with the AG. They have assigned a deputy attorney general to handle matters with this case because in addition to consolidation, there was a request for an extension of time because of the consolidation of cases. So they assigned a deputy, Chelsea Maha. So she's currently familiarizing herself with the case, and it came a little bit too late, so we couldn't put it on this agenda. So we'll put it on October's agenda for commission action. And it'll probably take place, in open session because it is really kind of a procedural thing. It's not really anything that would have to be pulled out into executive session. But like I said, I have a conflict on this case. I know Joan also has a conflict as well, but I think we have enough voting members regardless. Sorry, I'm a little bit sick, so I just caught a cold, so my voice isn't great. But okay, so an update on rulemaking. So, go ahead.
I asked you a question about about those cases, and so the next time we see them and the new deputy is present, what action are we going to take approving the extension or considering the extension of time?
Right. So the hearings examiner can usually is the one who decides motions during the hearings process, but the commission has to vote on whether or not to grant an extension beyond the 180 days because it's statutory. So the deputy attorney general will, familiarize herself with the case, look at the pleadings and say whether or not she believes, there exists good cause for an extension of time. So tentatively, because we have to, have the hearing take place within 180 days, then tentatively the hearing is set for January 9th, the week of January 9th. But most likely, an extension might be granted. But if not, all discovery, the hearing has to take place around mid-January.
Okay. So I just was asking that question because in terms of scheduling, we were considering skipping October because we haven't skipped a meeting at all this year. There's usually some break for you folks too, which is important. So I just wanted to make sure, but we can talk about that at the end of the meeting. So thank you.
Well, and if you guys want to meet like sooner or like if you guys, we would just have to put it on an agenda, so, a week or 2 out, we can do that. It'll be really fast, I think. But I just have to notify the deputy that she might have to come to a meeting. So, yeah.
Thank you.
Okay, so think that's updated on the docketed cases. Rulemaking. So, Robin's had been going through this process. She met with the Small Business Regulatory Review Board, got comments on that. The proposed rules were posted on our website for public review and comment. We didn't receive that many comments, but we did receive a couple. I also just got back our proposed rules from the LRB. So they kind of looked it over, made some suggestions because they're mainly looking at formatting, things like that. If we're missing like a semicolon, they, noted it, which was great, just to make it stylistically look better. Nothing substantive or anything like that. And I think what has changed from the last meeting, we were preparing to submit to the governor for his approval to hold the public hearing. So that actually has gone out. So we're just waiting for approval to come back. It most likely will come back in October, I'm assuming. But if not, they are really busy right now. But we'll probably get approval in mid-October, and then we have to, put out the 30 days notice of a public hearing. So that's going to take some time. We might not actually be able to hold the public hearing until November or December at this point, depending if we want to rush it through before the end of the year. So it's ongoing. And then we'll have to decide, if we're going to have the public hearing remotely, which I think is most likely going to be the case, and who from the commission might want to attend, if it's going to be everybody or just an appointed person to report back. But we have a little bit of time because we haven't gotten approval yet from the governor. I did send out the packet for this meeting, which consisted of a summary of proposed changes that we're doing. So I think I gave you guys two documents. So one was just a summary, so pulled out, all the changes. And then the second was the administrative rules in its entirety, so you could see exactly where it was all fit in. We tried to, I think we gave it to you guys in Ramsey format, so you can see changes, additions were underlined, deletions are struck through. But the major change that we're looking at is in the definition section. And part of the reason we're doing this is we want to make our definitions consistent throughout the rules. So for instance, the harassment definition, we feel like, harassment on any protected basis is prohibited, but for some reason we only included in certain protected bases in our rule. So we want to make sure everybody understands that you can't harass on any protected basis. So we use the definition from, I think, ancestry and sexual harassment, the administrative rules for ancestry and sexual harassment, to kind of apply to all the protected bases. The definition that got the most comments, and there weren't that many comments, like 2 comments, was the definition for employment. So I don't know if you all got a chance to look at that, but I could try to share my screen to show, let's see. Okay, I think I'm sharing it.
Yes.
Okay, awesome. So this is the definition for employment that we're proposing. And it's it pretty much mirrors other similar laws. So this is the definition for unemployment insurance, found in HRS 386-6, no, 383-6. And it's also in the administrative rules for TDI and the Prepaid Health Act. So it's kind of, we're trying to be a little bit more consistent on how we, analyze these things. And currently we have a declaratory relief order that was made, 30 plus years ago. That's really complicated for employers, for employees. And so this clarifies it. It's 3 factors versus 11 factors. So hopefully this will, clarify things for people. And I think one of the major benefits to adding a definition of employment in our rules is that people will know what to expect. So employers, they don't have to go digging through, our declaratory relief orders to find this older, decision with the 11 factors, which is very confusing. They can just take a look at our administrative rules and say, okay, employment's been defined. Okay, we have 3 factors. How do we analyze this? So I think it will be helpful, like, for everybody to simplify the analysis. And then the other major change that I did want to highlight is the pregnancy. It's not really a definition. So because of sex in HRS 378-2 includes because of pregnancy. So we are amending our pregnancy rules to, I feel like it goes more in line with 378, with our statute. So the biggest changes were eliminating the word disability for related medical conditions. So it's for a known limitation due to or resulting from pregnancy. And I think Robin might have touched on this, and we were kind of doing parallel things, but there's a recently enacted Federal Pregnant Workers Fairness Act, which goes much more in line with this new proposed change to our rules than our old rules, which was pretty limiting because you could have a perfectly typical pregnancy and still need to, get regular checkups at the doctors. But under our current rules, that might not be covered unless there was, a disability related to that pregnancy. So I think this it aligns much better with the intent of providing protections to pregnant employees. And it aligns a lot better with the new Pregnant Workers Fairness Act at the federal level. So those are the 2 things I did want to cover. I don't know, do you all have any questions after looking at?
Yeah, Connie, you said that there were comments on, in particular, the definition of employment. What were the comments?
Okay, so a lot of, because the 3-step process makes it a little bit easier to determine an employee status, they felt, that we don't have jurisdiction to create this, and they pointed to workers' compensation law, which doesn't use the 3-factor test. But I do feel like because TDI, because unemployment insurance, and because the Prepaid Healthcare Act also use this 3-factor test, it helps bolster our reasoning for why we want to use this. Another reason also is the declaratory relief order that we rely on, the 11 factors that we currently use. In that order, it points to unemployment, it points to, TDI as having all these factors, but over the years, they simplified it into this 3-factor test. So it kind of goes along with, we need to update how we analyze these cases to be more consistent across the board for, employers who have to deal with unemployment, TDI, things like that. So that was just, one of the comments on our proposed definition for employment.
Connie,
Mm-hmm.
I mean, would you also say that the national trend is toward this more simplified scheme anyway?
Yeah, and Robin was much more involved in, drafting and proposing these rules, but she did mention that I think over 20 states have enacted this 3-step analysis rule, and California has it in particular. So there's a lot more case law, so we can, use that as guidance as well. But yeah, I think it's the national trend is to simplify the analysis rather than overly complicate it.
I also had another comment with regard to the pregnancy definition, where I think for many, many years, our pregnancy law was terrific and provided much greater protections for pregnant individuals than most other states. But the Pregnant Workers Fairness Act has sort of superseded the protections that we had in our law, and I think it is
It's
uh,
excellent. Yeah.
excellent, and it's good to sort of conform to that standard. And it'll be a great benefit for workers, in my opinion. Yeah.
Hmm. No, I definitely agree because, you know, disability doesn't show up in 378 chat part 1. So our administrative rules kind of put a constraint on, you know, who would qualify for protections for, you know, additional leave or accommodations. So I think this definitely helps broaden the protections for pregnant individuals. I just realized something. Okay, so one of the other changes that we want to do for the pregnancy protection section is to eliminate gender-based language, and I just realized there's one that we missed. So, but we tried to just say, you know, pregnant applicant instead of her, but I realized we missed that one. But anyways, so
That's great, Connie. So I would encourage our commissioners to review the materials that Connie had sent out, and then if you have any questions, to contact Connie, and she can follow up on that. Connie, I was just wondering, I thought that the rules had to go to the Attorney General's office. Is that not the case?
I think we're working with an attorney general on these rules, and I think they approved it already.
Okay.
But they had to write their approval to the governor. So it had to go through attorney generals plus the Department of Labor and Industrial Relationships to go to the governors. So they were both working on the approval process from that. So
And so they already did, at least
yeah,
verbally or however they
yeah.
did approve the
At
version
least to
that.
my understanding, the last
Okay.
communication that Robin had with our attorney general.
Okay, thank you.
Okay.
Are there any other questions for Connie?
Am I still sharing my screen? Okay,
You
stop
are.
share. Okay.
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 That's great, Connie. Anything else from you on the chief counsel's report?
No, I think that's it. Yeah.
Great. That was great. Thanks, Connie. We're gonna go back. Joan has joined us, so we're gonna go back and approve the minutes from August 22nd, 2023, which were circulated by Marcus. I just wanted to see if you folks had any corrections to those minutes. And I can see everybody, so unless you, I see no comments. So the minutes from August 22nd are approved as circulated. And then we'll go to the executive director's report. And we are being mindful, Joan, of your time too. So we will go to the executive director's report, and when you have to drop, it's okay.
Okay. I'm going to start sharing. And I think we should have the mediation program year to date up.
It is.
It's been a pretty slow couple of reports for mediation. I'm sure things will pick up, but there were 4 additional cases that were referred into the mediation process since last meeting. 4 cases went, not the same cases, but 4 cases went through the mediation process. 1 resulted in a settlement and 3 did not. And so for the fiscal year to date, we have 1 settlement versus 4 non-settlements. Overall success rate of 20%. Still early on. I mean, I'm lots of room for improvement there, which I'm sure we'll see. The 1 case which did settle was a housing case, and it was a dual filed housing case, and the primary basis of that case was sex. And when I looked at it, it's a sex gender identity type of case, which is we don't see too many of those, but it's good that we got a settlement there. And that one case you'll see as I scroll down was through our internal process. In fact, all 4 cases that went through the mediation this period went through our internal mediator. One out of those 4 did settle. And like I said, overall, we have a 20% success rate for the fiscal year. Yeah, so not a whole lot to report. And I am going to look to see if there's something in terms of, there seemed to be not too much activity for that past 2 reports, and I'm curious as to why that might be. Other than that's really all I have for the mediation report. Does anyone have any questions on that? No? Okay.
Thank you.
I'm going to go ahead with the caseload report. And okay. There weren't too many dramatic changes since last time in the overall makeup of our caseload. There are, these cases that were filed in 2017, 2018, 2019, we just are going to have to come to some sort of disposition and resolution of those, and we're going to make an effort to do that. But I do see, if you look at the changes from last report, we have had, we had 1 case from 2018 close and 1 from 2019, but the majority from more recently filed complaints. And in fact, the highest category was with the cases here in 2023. We had 15 complaints filed in 2023, which closed, which is a pretty good number, actually. Overall, 1 additional case in our caseload since last report, so up to 346. And going down a bit, so the case aging, this is the overall percentage based upon age of case. And so not too much difference if you compare, this column versus this last report. Roughly the same, percentages, which we've been reporting. I mean, it's trending too much toward the old end of things, and so we are making efforts to reverse that. I can say that we, unfortunately, we did lose one of our investigators. Yesterday was his last day, and so we are going to make efforts to fill that position as soon as possible. But the more newly hired investigators that we have on board already have been very good, and we're training them up to do more complex investigations. Likewise, breakdown by type of case, pretty similar to last report. We do have a pretty large number of cases, very large number actually, in the response monitoring stage. So cases which have been filed, and then we're either getting a response or we're getting information to allow us to move forward to the next stage of the process. And not too many cases pending assignment, so they're assigned to investigators for actual investigation. I'm gonna scroll down to the bottom. As soon as I've been saying this, but as soon as we have our annual report out, which actually should be, fairly soon, we're going to add the most recent year's column of statistics here, of course, and we can make some comparisons. But scrolling to the very bottom, we have our year-to-date comparison. And I think consistent with what I've been reporting, if you take a look at the pre-complaint questionnaires received, we are really coming back towards the numbers we had prior to the pandemic. So the 124 pre-complaint questionnaires received is significantly higher than the previous year's amounts. And if you take a look at the intake decisions, which means that cases where we assigned the case to an investigator and the investigator did an intake interview or did some analysis and determined whether or not the case was jurisdictional, and if the person wanted to go forward, we would, draft and file the complaint. So 137 intake decisions, which is really, right where we were back prior to the pandemic in 2019 here. So that's good news. And we have a good number of complaints filed, as well as investigations closed. a little light on notice of cause and enforcement closures, but that's sort of just dependent upon the flow of cases. So I think that will increase as we go on throughout the year. So yeah, I mean, I think the one trend that we wanted to see reversed for cases actually coming in our door, we definitely are seeing a positive trend there. And okay, so that's my report for the caseload report. Any questions from anyone?
It's that case from 2017. Is there anything you can tell us? It says if you go back up your screen,
Yeah.
if I remember correctly, it said it's still being investigated. The
Yeah,
investigation.
it's in
Active
active investigation. It's hard for me to give you much more detail than that, other than it's in the hands of an investigator. And you know, cases that are that old, typically there's a reason for it. Either it's very complex, the parties are just, you know, impossible to work with. So yeah, I mean, that's one where we just need to get it done. I mean, I have no nothing to say other than that. And so hopefully we can report back soon that that case has been has reached some sort of disposition. Yeah.
Is that case employment discrimination or housing or
That's employment. I'm aware of
employment?
that case. Yes. Yes.
And Marcus, it's not because you do not know the substance of the case, it's that we are keeping the investigation and adjudication separate. That's right. Right.
Correct. Yes. I'm sorry if I didn't make that clear. Yeah, I'm just not able to provide that the detail of information to you. Yeah.
Thank you.
Sure.
Are there any other questions for Marcus? You have to just speak up because Marcus has sharing his screen, so I can't see anybody. Or I can see 5 people. Okay.
Okay. If
Thank
that's
you.
it, I'm going to stop sharing now.
Okay.
Okay.
Thank you, Marcus.
Mhm.
So we're gonna move on to announcement of the next meeting. Connie, if you think that it's okay that we don't schedule an October meeting unless there's a need to for the extension. I know that the parties sometimes want to know whether or not they're granted an extension because then they know whether or not they need to work on certain things before the hearing. So is that okay that we skip October, and then if it becomes imperative, you can reach out to us and try to schedule something, or would you rather us have something on calendar?
I mean, it could be a really short meeting. The only worry I have is because it's so truncated already, like it's a truncated process already. If we don't grant an extension before November, that's right next to January where they have to already have, discovery done.
Okay.
So it would be my preference that, we can have like a 10-minute meeting. But if it doesn't work with schedules, yeah.
Okay, let's just try to do that for the purposes of this case.
Okay.
And then we won't have to do the reports. And one, because Marcus is working on the annual report, so we're gonna get that information in total for the fiscal year, right, from Marcus at the next meeting or the one after that, right, Marcus? And then Connie, you can report on any litigation if there's anything that happens, but otherwise it's status
Okay.
quo.
Yeah, that works. Okay.
Okay. So, when do you think we need this meeting, Connie?
It's really up to your all of your schedules. If you guys would rather have it, I guess, sooner rather than later, we do have to, put out an agenda, so we need at least 6 days notice to do that.
So we can do it on the 10th or the 17th, and 2 o'clock, if that's okay with everyone. We've been kind of trying to do that. Joan, I know your schedule is a little tight on the school. Does the 17th or the 10th work? You're muted, I think.
I fly out the night of the 10th, so
okay.
that's kind of tough. But if the meeting is at 2, I don't think my flight's until late that night. And that actually, of the 2, would probably be better for me, provided that it's not a meeting that turns out to go much longer than intended.
Yeah.
Because
Okay.
the 17th just gets to be, we're just back at school and
Yeah.
after break.
Okay.
Or
Arsima.
earlier, like at 1.
Yeah, that's fine. I mean, either one of the, like, the 17th is fine as long as it's, again, I could stay probably as late as 4
Okay. Let's try
if
for the
needed.
10th. Let's try for the 10th at 1 o'clock. Arsima, John, does that work? Okay. Let's do that. So that we can, and this meeting is it's just for the purpose of evaluating the motion for extension or the request for
Okay.
extension. But if something does arise with regard to the other litigation or the rulemaking that we need an update on, then Connie can provide that and file the agenda accordingly. Okay, so let's do that. 1 o'clock on the 10th.
Okay.
Short meeting. Okay. So kind of like a break, but not really. All right. Anything else? Any announcements? Okay, I do not see any announcements. All right. So I'm going to adjourn the meeting at 3:33.
Thank you all so much for doing this and accommodating me. I appreciate it. I'll see you all in October.
Yeah.
Nice to see everybody.
Are you gonna be in Alaska, Joan?
I'm going to be in Alaska. Yep.
Oh, okay. Have a great trip.
Thanks for attending, Heather. Thanks, Sandy. Bye.
Bye.